Look who's here. Is that? Hi.
Hello.
Photo bomb. Blake Lively, who I love. Goodbye, Hurricane Blake.
Well, we don't know what we're doing.
Yeah, what are we doing?
You're blocking my camera.
Sorry.
Thank you.
What would I say? That's a good question. Let me think about it for 5 minutes.
You're leaving. And what item have I taken from set?
Clothes.
A vase.
Specifically boots.
Brandon knows me the best, you guys. Unfortunately, none. I usually loan my stuff to set, and those were my boots.
Hey besties, it's Katie from Without a Crystal Ball. Well, Blake Lively's attorneys were super busy last night flipping out because Wayfarer had exposed them for issues related to Taylor Swift. For a very long time, they had been trying to tell the public and the courts that it was Wayfarer and Wayfarer alone that was bringing in Taylor Swift to the case, which we all know is false because it was Blake that was on the promo tour talking so much about Taylor, saying that they were together, hand in hand, shoulder to shoulder, and that she was with her through it all. And it was Blake that represented to Isabella Ferrer that it was Taylor that cast her in a film. And it was Blake that name dropped Taylor all over the place when it came to music and creative decisions. So there was a lot that was going on here, and it certainly wasn't Wayfarer bringing Taylor into the mix. Wayfarer had provided a string of attachments when they were fighting against this protective order for Taylor Swift's emails. And they stated that Blake had just only a few weeks ago or a week before amended her initial disclosures. And it said documents and communications with Taylor Swift, who, according to Lively's amended initial disclosures, has knowledge of the party's alleged conduct. Complaints or discussions about the work environment or conduct on the set of the film, the production, editing, cut, creative process associated with the film, publicity surrounding the film, the retaliation campaign alleged by Miss Lively, and the resulting damages suffered. So she represented to Wayfarer that Taylor was a witness that had information, relevant information, and she put this in her amended initial disclosures, and including the production, editing, cut, creative process associated with the film, which Wayfarer has said all along that Blake was representing that Taylor was more involved. And Taylor's representatives has said back in May when they were subpoenaed that she had no involvement, that she didn't make any creative decisions, she had no part of editing, she didn't casting. So it's at odds with what Taylor has said. Well, they wanted a protective order, and Wayfarer was saying, well, we're only asking for this because she put this in her amended initial disclosures, and she says she has relevant information that she can provide to us about her emotional distress claims. Kevin Fritz also told the court that on May 22nd, Miss Swift's attorney notified Lively that no communications between Miss Swift and Miss Lively had been provided to the Wayfarer parties because nothing had been produced. So when they contacted them later that day and demanded that they hand over any documents, Fritz says they already knew that no such documents were in their possession. And then he said that he contacted them on June 12th to talk about her amended disclosures and the communications with Miss Swift, and that they had a scheduled meeting, and then only a few minutes before the meeting, they filed this motion for a protective order. And then when they were trying to talk on the phone on June 13th, they refused to discuss the issue and told them that they could deny the motion or, go to the court and dispute the motion. And it says, on the phone call, I explained to Miss Lively's counsel something that they already knew. The Wayfarer parties are entitled to communications between Miss Lively and those non-parties identified in her amended initial disclosures as having discoverable information. So when someone files a lawsuit in federal court, within, I think, the first 14 days, you have to do what are called your initial disclosures, which you have to tell the other side who are the people involved in this case, like your witnesses or other people that have information that could be used to support your claims or your defenses. And so they have to send them a initial disclosures list, and they have to provide names and addresses and phone numbers of any individual that's going to have discoverable information along with the subjects of that information that the disclosing party may use to support its claims or defenses, unless the use would be solely for impeachment. So if Blake names Taylor as having relevant information, what Wayfarer can do is they can ask Blake to provide information about between her and Taylor that is relevant to the claims in the case. And according to her current lawsuit and what she disclosed Taylor would know, she said that Taylor knew relevant information about misconduct on the set and was able to provide information about emotional distress and the damage that it caused to her because of an alleged smear campaign. So the quick recap is on June 12th, Kevin Fritz brings up what Blake Lively had provided on her amended initial disclosures. He also brings up her limited production, and he says he wants to talk to them on the 13th, and then they have it scheduled the next day. And before they even have the meeting, then they run to the court and file for a protective order for Taylor Swift's communications, even though that was on the email of what he wanted to talk to them about at that meet and confer, basically not allowing them to have the conversation. And so she bypassed the meet and confer. And so now Blake's team is going to respond to that. And they're now trying to say that they're trying to distance themselves, Wayfarer is, from statements that they made publicly that they got exactly what they wanted. And the statements that she's trying to tie them to, Ezra are insider quotes not attributed to literally anyone. So it could be somebody that knows someone who knows something. We don't know who said what, and it's not attributed to anyone on the legal team. So they're trying to say that this came from Brian Friedman, but yet Brian Friedman is not quoted as saying it. So that might be difficult for them to prove to a judge. But again, this is Judge Lyman. I don't know how he's going to rule. But they said, as to Lively's motion for a protective order, the Wayfarer parties argue that Miss Lively is bound by her amended initial disclosures to produce all privileged communications with Miss Swift. They provide no authority for this proposition. If including an individual on a party's initial disclosure binds a party to produce all non-privileged communications with that individual, the Wayfarer parties would have agreed to produce all communications as between each of the Wayfarer parties. On the other hand, and the 137 non-Wayfarer parties identified on their initial disclosures on the other, they have not. So they're kind of deflecting here. It's like, it's just a non-answer, really. Well, Wayfarer hasn't disclosed any of their witnesses, which doesn't really answer the question. That's my opinion. Instead, Rule 26 contemplates initial disclosures as a mechanism to ensure timely disclosure of names and identifying information for each individual likely to have discoverable information. To be clear, Ms. Lively supplemented her initial disclosures to include Ms. Swift after the public representations that the Wayfarer parties got exactly what they were seeking, were provided with everything that they needed, and got exactly what they were hoping for and much more in connection with Miss Swift, which suggested that they would be producing information in connection with the case. So they're taking an out-of-court statement by an unknown insider to prove this argument to a judge, which is a little bit difficult. And then they're saying that Blake only included it because of that, which doesn't make sense. If their attorneys, Venable and Swift's attorney, told them that they got no information, then technically that's true. They got no information. Now, from Wayfarer's point of view, I know a quote, one of the quotes was that they got what they wanted. Taylor Swift denied that she had any involvement in the case because that was the public statement. A public statement was made by Taylor. It says, we didn't do anything with creative. We didn't do any with film. We didn't do anything with that. So that could have been what they were seeking, a denial, because it proved Blake was lying. But they don't put that in here. And I believe that's actually in that same article that they keep referencing. But again, this bait and switch cannot provide as a basis for them to obtain discovery on what the Wayfarer parties supposedly already had. The Wayfarer party's speculative argument that Miss Swift's communications theoretically could have communications relating to Miss Lively's emotional distress does not change the calculus. For starters, the Wayfarer parties appear to be attempting to bring a cross motion to compel far more than communications with Miss Swift relating to Miss Lively's emotional distress, meaning under the most generous interpretation, their attempts as to discovery in connection with Miss Swift are wildly overbroad, and their focus on emotional distress is simply a post hoc rationalization for those requests. Further, the Wayfair party's position that Miss Lively and Miss Swift socializing at dinner would yield written communications on the topic is nonsensical. Instead, they have stated when recently explaining the state of play as to Miss Swift, this is what Brian Friedman told to Megyn Kelly. There's a short leash on how far we can go with discovery. I think the judge has made it very clear that, third parties need to be directly relevant in the claims. And we think certain third parties are directly relevant, but it's just whether or not you need that evidence in addition to what you have already. They're trying to say that this implies that they had evidence from Taylor Swift, but what I felt like he was saying, and this is what I mean, is like if they already have all this other evidence that isn't pertaining to Taylor, they have to decide, well, do we need Taylor's communications or do we not? Because if we have all this other evidence from other people that supports our claims, do we need her? So that's what he's trying to say is like, do you need to add that if you don't? For the reasons stated in her motion, the court should hold the Wayfair parties to these public representations and conclude that the issuance of a protective order is appropriate to protect Miss Lively from the unreasonable cumulative discovery that, as counsel for the Wayfair parties appears to recognize, denying motion to compel discovery that is unreasonably cumulative of information already produced in discovery. So their argument again is that Kevin Fritz is lying under oath in a sworn declaration that he has no information from Taylor. And they're again trying to say that they already have this information, even though Wayfair says we don't. Really, their argument about this Taylor Swift stuff hasn't changed. They don't believe them when they say that they don't have information from Taylor, even though Kevin signed a document that said they don't have it. Her attorneys told them they didn't have it. And so they're trying to claim that because of some insider making a vague statement, this is proof that they have it. And so that's why Blake shouldn't have to disclose it. They argue that the cross motion is improper, and they're providing no support for their position that she must produce some subsets of information in advance of others. As they are well aware, despite being a single individual, she has produced more than anyone else in the case. Then they tell the court that she already made a production last Friday and she's going to be continuing to produce. And then they go into the hard bargaining, I guess, is what Judge Lyman has referred to Blake, where she's being requested to give something. And so she in turn then says, well, then you need to do this for me. Hard bargaining, I guess, is what they call that. So they tried to get them to compromise about Blake giving them what they need. And I'm thinking they want some of this ahead of her deposition. But what she wants from them is the following. In an attempt to resolve the issue earlier this afternoon, Miss Lively proposed to the Wayfair parties that they produce all video footage related to the film, some of which they have selectively released to the public since January, but not produced to Miss Lively. Full unredacted versions of communications that are excerpted in the Wayfair party's amended complaint and Exhibit A, each of which is responsive to her request for production. And in return for mutual production on the categories the Wayfair parties identified, all by the end of next week. And the Wayfair parties did not agree to any production in advance of July 1st. Thus, there's no basis for the request to compel Miss Lively to do so. What I find odd about that whole letter is that on the one hand, she was accusing Wayfair of seeking more information in their cross motion than what was sought related to the protective order. So she said, well, Wayfair came here to fight the protective order, and then they did a cross motion compelling her to produce everything else. And then to make it even more confusing, they then bring in their own argument with Wayfair and said, well, we'll produce that if you produce this. And so then Stephanie, the one that did the Van Zandt Inc. sham lawsuit, she comes in with her declaration, and she's going all the way back to March 24th, only to add more confusion. And it's to show them that they're not producing documents. It's like this has nothing to do with what Wayfair is seeking. It's just sort of like a retaliatory response. It's, well, they didn't give me this, so why should I give them that? And now you can understand why it would be really exhausting to be Wayfarer because anytime they fight back, this is how they retaliate and they make them look like the bad guys. So she goes back to March 24th. She claims that they've been asking for all of this, the audio and video recordings, the notes and production logs concerning intimate scenes related to the film, whether or not included in any cut of the film. And then on number 23 for Tag Nathan and Abel, for Baldoni, and Sony, WM Jones Works, any media outlet of any kind, any social media accounts or influencers or other individuals who maintain a public presence or any cast or crew members, blah, blah, blah. So they're telling them that they want all of these documents and that they haven't given them to them yet. So when Wayfarer says she won't give us any information about damages, she won't give us any information about sexual harassment, they come back, well, they won't give us information about this, they won't give us information about that. On June 17th, I was copied on an email from my counsel to counsel for the Wayfarer parties asking when they intend to produce the footage and full unredacted versions of communications in the Wayfarer parties' amended complaint and Exhibit A. My co-counsel suggested that the parties could agree to a mutual production by the end of this week so that aforementioned categories in exchange for the categories identified by Wayfarer parties in their cross motion to compel. That same day at approximately 8:45 p.m., counsel for the Wayfarer parties indicated that they will produce the documents by the July 1st substantial completion deadline. Counsel, however, did not indicate that they agreed to a mutual production along the lines described in paragraph 3 and did not agree to make the production in advance of July 1st. So their whole argument here is basically that, well, they're not willing to give us information, so why should we give them information? To again, just make it look like Wayfair's not complying. It's just adding in more arguments to so that Wayfair is looking unreasonable. And truthfully, they don't have to really negotiate anything here. If Wayfair is seeking these documents, they don't have to agree to compromise. They can still ask the court, right? And I think they're probably wanting this because of the depositions. And Kevin made clear in his email on the 12th that unless they can come to some sort of agreement about when she's going to disclose this, that they'll have to take it up with the court. So they knew that a motion to compel was coming. They knew it, which is why they ran to the court for a protective order. And then now all of this is just trying to confuse the court again. And again, trying to say that the double hearsay, they didn't deny it. I feel sorry for Wayfair, to be honest. So Blake's team is panicking. They're trying to lie about why they brought up Taylor. They're trying to blame Wayfair for out of court insider statements that are not attributed to anyone on the team. So, with that said, there's also a response from the judge on the motion to compel, which we were talking about yesterday. And it went denied in part, granted in part. And this is what it was about. It had to do with those emails, it had to do with content creators, and it had to do with reporters. And he agrees with Wayfair that Ryan Reynolds is not a part of this lawsuit. And so he cannot seek any discovery at this point in time. And they were looking for a count interrogatory, which says identify an email account from May 1st, 2024 to date in which any third party, including but not limited to content creators or media, had access for the purpose of communicating information of any kind, including messages, talking points, guidelines, scripts, or information regarding Miss Lively, Mr. Reynolds, the digital campaign, and the CRD complaint or actions. And Reynolds provided that to each one of the Wayfair parties, but Lively only provided that to Tag. And while this motion to compel was pending, the judge actually dismissed all of the claims against Reynolds. They did grant leave to amend certain claims, but as of right now, Reynolds is not a party. And then the Wayfair parties agreed that Tag would provide a supplemental response to Lively, and Tag responded. And none of the other parties responded because it was impermissibly vague. And they said it's denied because the wording of the interrogatory is sufficiently specific to enable a targeted response by the parties. However, Reynolds is not entitled to responses to this interrogatory because he's not a party. And as a party, Reynolds would be entitled to discovery relevant to any party's claims or defenses, but there are no current claims or defenses in the case which he was formerly a party, and therefore nothing to which discovery would be responsive. The mere possibility that amended complaint may be filed is no basis for the court to compel discovery regarding issues that are not pending and may never be pending before it. Reynolds may renew the motion if, after filing of an amended complaint, the requested information is relevant to a claim or defense in an action where he's a part. And then when it comes to Miss Nathan, they told her no. And so there's nothing for them to give. And it says it's denied as moot for Tag because they responded. She expresses dissatisfaction with the response, and the court understands Tag to have construed the word access to include login credentials by placing information in a draft folder, and thus to have, and they said no. And they said to the extent that Tag has answered the interrogatory falsely or inconsistent with that understanding, other remedies may be available. But she said that none had been accessed, and then he's leaving a door open in the event that Tag is lying, but that's ridiculous. And when it comes to disclosing what reporters they have talked to since the filing of the motion, with Wayfarer sort of mocking this idea that there's an ongoing smear campaign, the judge didn't decide the truth or the falsity of that. He just said that they can seek information from Wayfarer up until the present when it comes to if they've spoken to any reporters. And that information can be used by Blake to prove whether or not the smear campaign is true or false, the ongoing aspect of it. It would be really stupid if they were doing anything behind the scenes at this point. So I highly doubt that they're going to get anything from that. And making comments publicly by attorneys is vastly different than the parties involved in this case saying anything at all. So Wayfarer does have to provide information about what reporters they spoke to, if any. And here's the thing, a smear campaign itself, the word is not actionable. Speaking to a reporter and answering questions is also not actually actionable. In the United States, we all have an opportunity to say whatever it is that we want, freedom of speech. Only defamation is only actionable if it's what you're saying is knowingly false or you're spreading information with reckless regard for the truth. And so you didn't do any verification of what you're saying. And then with public figures, you have to prove malice. So speaking to a reporter in and of itself and being honest and truthful isn't a smear campaign. And just saying something negative about someone doesn't mean that it's a smear campaign. It doesn't mean it's even defamation, because it can be your opinion, and opinions are not actionable. It would be like me saying, I don't like Ryan Reynolds. He can't sue me for saying that. That's my opinion. So I don't look at that as necessarily a bad thing. I just don't think they're doing it. So if they have to hand anything over, I don't think they're going to find any evidence of a smear campaign. And then they will just have to identify the reporters that they've communicated with in any manner. And then as far as the content creators, it said Lively asked Tag if she's spoken to anyone, and Reynolds asked all the remaining Wayfarer parties. And they have agreed to define the term content creators to mean any individual or entity who seeds, generates, creates, or influences social media content or provides related digital or social media services. The motion is granted as the content creator interrogatory propounded by Lively to Tag, which they stated is not hopelessly vague or unduly burdensome, does not include any person who can generate, create, or influence content, but only the much smaller subset of those who do so on the behalf or at the request of a given Wayfarer party. So at the request or on behalf, meaning they sought out a content creator and asked them to put something out for them. And if they didn't do that, it's going to be simple, none. So, and if they did, they just have to say who. And she's only asking Melissa. And then with regard to Ryan, it's denied because there's no claims against him. I know some people will be upset with this ruling because they'll say, well, why do they have to disclose the names of reporters? Because that's one of her claims is a smear campaign. Why does she have to disclose information about a content creator? Because that's about the smear campaign. And why does she have to do it after? Because she claims it's ongoing. Whether or not that's true or false, it comes down to discovery, right? But what I will say about discovery is, and lawsuits, and just what I would say, my advice is that if you don't want your words to come back and be put into another filing, just don't comment on the lawsuit, right? Anytime you say something publicly or speak to someone about the lawsuit in a public manner, whether it's through a reporter or a content creator, they'll bring that to the court, which we've seen over and over and over again on both sides. Anytime a statement is made, it shows up in a filing by one of the lawyers. Now, Blake is trying to attribute an insider quote to the Daily Mail as coming from one of the lawyers, right? But they have said that's not true. Speaking to a reporter isn't necessarily a smear campaign. It depends on what it was that you said to them, the information provided. Simply repeating your opinion isn't a bad thing. It's not actionable. Smear campaigns and speaking negative about someone is also not actionable. And if they're responding to something that your side put out, it's as simple as saying, we spoke to this reporter after you issued a statement to them, right? It doesn't necessarily mean that it's a bad thing, and it doesn't mean that a smear campaign happened. It's my opinion that Blake and Ryan view any discussion about them that isn't positive to be defamatory, and that's not what defamation actually is. Freedom of speech allows you and I to speak without consequence so long as what we're saying is true. And with public figures like Blake and Ryan, they have a very high burden that they have to overcome to prove defamation because they have to prove, like Wayfarer would have had to prove, they have to prove malice. And malice is an extremely high hill to climb. It means that you either had to do one of two things. You had to say something that you knew was not true, and you did so with the intent to cause harm, or you spread something without regard for whether or not the information was true, which again is the intent to cause harm. But if you simply share something that you know is true, or if you share something that is your opinion, that doesn't qualify as defamation. Now, if you accuse someone falsely of a crime, like Ryan did, but you believe it to be true, according to this judge, that's apparently not defamation because they claim it's his opinion and he believed it, which I don't know about that. But either way, Blake's team is obviously panicking because they are now caught bringing Taylor back into it. And now they're trying to flip the narrative and say, well, they're the ones that told us they had this information because of this unnamed third party that said that they got all that they needed. And so we shouldn't have to, provide everything because they got what they needed. And we don't want to give anything to them because they haven't given anything to us. How the judge will rule on that, I don't know. He could, again, he might just say no to all of it. You know what I mean? Like denied, 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 denied. Or he might say granted, 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 granted. This is the joy of discovery. I'm not a lawyer, so I can't tell you, but I just think that there's so much gaslighting that goes on, and Blake's team is very good at confusing the judge. So don't be surprised if she gets a protective order for Taylor, I guess. I don't know. We'll have to see what happens. But to me, I don't really care what happens because Blake just proved that she's scrambling and panicking. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.